We are pleased to present our paper called How Could Equality and Data Protection Law Shape AI Fairness for People with Disabilities? I'm Reuben, Associate Professor in Human-Centred Computing at the University of Oxford.
And I'm Reuben Kirkham, Lecturer in Inclusive Technologies at Monash University.
AI has the potential to help people with disabilities, but also, if not designed carefully, lead to harm. The emerging field of AI fairness seeks to assess and mitigate such harms. The legal system can support or constrain such efforts. For instance, it can be used to ban or limit AI which discriminates against people with disabilities, or it can mandate that AI systems be adjusted to meet their needs. This paper focuses on two important bodies of law: equality and data protection. While our analysis focuses on the UK, it's also relevant to EU countries which share similar laws.
Equality law protects individuals from direct and indirect discrimination on the grounds of protected characteristics, such as race, sex, and disability status. It also offers special protections for persons with disabilities, most notably the duty to make reasonable accommodations or adjustments. Data protection law, on the other hand, protects individuals' fundamental rights in relation to the processing of their personal data. AI fairness for persons with disabilities can be supported by existing equality and data protection law in the European Union. But those laws may in some cases present barriers or challenges to such efforts. We argue that, due to the unique ways in which disability is treated in equality law, it's important to have a separate body of principles and approaches towards AI fairness when designing either for people with disabilities, for example, the development of assistive technologies, or creating systems to be used by the public at large by way of universal design, which includes, of course, people with disabilities. At the same time, we offer a positive new agenda for assistive technologies researchers and practitioners, as well as disability rights organisations, who may be able to take advantage of opportunities provided by legislation to more effectively advance the rights of people with disabilities.
In the paper, we draw out the key provisions from equality and data protection law which affect AI fairness for people with disabilities. For instance, data protection law protects personal data and puts in place specific safeguards around the processing of personal data. AI systems which put people with disabilities at a disadvantage are prohibited under equality law, and in some cases it may be required for an AI system to treat people with disabilities more favourably as part of the reasonable adjustment duty. However, in some cases, equality and data protection law are not completely aligned. For instance, while equality law treats disability differently from other protected characteristics, within data protection law, disability is treated similarly to other protected characteristics. Equality law is mostly based on individual complaints, whereas data protection law includes forms of forward-looking risk assessment and mitigation.
Understanding the law better in relation to AI and people with disabilities can help researchers, disability rights organisations, and others to challenge harmful automated decision-making systems, to undertake AI research involving data about people with disabilities in a legally compliant and trustworthy way, to support people with disabilities in making claims against AI systems and organisations that misuse them, to use data protection rights in order to obtain information from AI providers, which in turn may help assess AI fairness, and to advance the role of disability rights organisations in AI fairness by making use of the substantial public interest exemption allowing the processing of disability data.
Thank you for watching our video, and we look forward to discussing this further with you.